Hello, everyone. Welcome back to our channel, U.S. Immigration News. We hope you're doing great. Well, in today's video, we will be talking about updated USCIS rules for work authorization, automatic EAD and mandamus litigation speed up. So to get all the information, pay attention and watch the video through to the end. Please hit like and subscribe, and don't forget to push the notification bell for upcoming episodes. So, without any further delay, let's jump into the video. In recent weeks, the United States Citizenship and Immigration Services, USCIS, has implemented several significant changes to its Employment Authorization Document, EAD policy. These changes aim to streamline processes, reduce backlogs, and provide better support for immigrants working in the United States. This video will delve into the specifics of these changes, their implications for different categories of visa holders, and the steps individuals can take if they face delays in obtaining their EADs. EAD policy changes. Decoupling EAD from other immigration benefits. One of the key changes USCIS has implemented is the decoupling of employment authorization from other immigration benefits. Traditionally, when a foreign national filed an I-485 adjustment of status application, they could also apply for an EAD and Advance Parole. Typically, USCIS would wait to adjudicate both applications simultaneously before issuing a combination card. Now, USCIS will prioritize EAD applications, issuing them separately from apps to reduce backlogs and speed up processing time. Automatic EAD extensions for additional categories. To address the worsening delays in EAD processing, USCIS has introduced automatic extensions for certain categories of visa holders. This includes H-4 dependent spouses, whose work authorization will now be automatically extended if they file an EAD renewal application before their current EAD expires and hold an unexpired I-94 showing their non-immigrant status. This policy aims to mitigate disruptions to employment and reduce the number of new EAD applications. Exemption from EAD requirement for certain visa holders. USCIS has updated its guidance to allow certain E&L visa non-immigrant spouses to use their I-94 form as evidence of employment authorization without needing a separate EAD. The I-94 forms will have new codes EAD. The I-94 forms will have new codes EEU1SE to reflect this authorization. This change reduces the burden on both the applicants and USCIS by eliminating the need for additional paperwork and processing. Implications of EAD changes. Impact on different visa categories. H-4 visa holders. H-4 visa holders, particularly spouses of H-1B visa holders, have historically faced significant challenges with work authorization. The automatic extension of EADs for H-4 spouses is a crucial development, allowing them to continue working while their renewal applications are processed. This change helps prevent employment gaps and financial instability for families relying on dual incomes. E&L visa holders. E&L visa holders' spouses benefit significantly from the new policy that exempts them from needing a separate EAD. By using their I-94 form with the new COA codes as proof of work authorization, these individuals can start or continue employment without delay. This policy simplifies the process and reduces the administrative burden on USCIS. U-Visa petitioners. USCIS announced a policy update for U-Visa petitioners, granting employment authorization and deferred action to those with pending bona fide petitions. This change aims to provide immediate relief to victims of crimes who are assisting law enforcement and their qualifying family members. Current EAD processing time. EAD processing times vary depending on the service center and the type of application, as of the latest updates. I-485 EAD processing takes between 2 to 6 months at the National Benefits Center. H-4 Spouses EAD processing ranges from 4 to 8 months at service centers in Vermont, Texas, Nebraska, and California. However, in reality, processing can sometimes take up to 1 to 1.5 years. Causes of delays. Several factors contribute to EAD processing delays, including office closures. During the COVID-19 pandemic, USCIS closed offices for interviews and biometrics appointments, leading to significant backlog. Biometrics appointments. Delays in scheduling biometrics appointments have stalled the adjudication of many applications, including I-765 applications for employment authorization. Resource constraints. Limited resources and staffing issues have exacerbated the delays. Legal recourse for delays. Mandamus litigation. What is mandamus litigation? Mandamus litigation involves filing a lawsuit in a U.S. District Court to compel a government agency, such as USCIS, to take action on a delayed application. This legal remedy is available when an applicant has experienced unreasonable delays that cause harm. Filing a mandamus lawsuit. To file a mandamus lawsuit, consult an immigration attorney. It is crucial to seek the assistance of an experienced immigration attorney who can navigate the complexities of the legal process. File in U.S. District Court. The lawsuit must be filed in a U.S. District Court, where a federal judge will order USCIS to issue a decision on the case if the delay is deemed unreasonable. Costs and success rates. Attorney fees. Typically, attorneys charge around $5,000 or more for handling a mandamus lawsuit. Court fees. The court fee for filing a lawsuit is approximately $402, while the success rate for these lawsuits is high, over 95. There are no guarantees of speedier processing. However, many applicants have found this to be an effective way to compel USCIS to act. Alternative strategies to expedite EAD processing. Expediting requests. Applicants facing delays can request expedited processing of their EAD applications through USCIS Customer Service. Call the USCIS Customer Service number to request expedited processing. Written requests. Write a letter to the service center or field office handling the case. InfoPass appointments. Schedule an appointment with a USCIS officer via the InfoPass system. Criteria for expedited processing. Expedited requests are evaluated based on specific criteria, including health or emergency situations, urgent health-related issues for the applicant or their family members, severe financial loss, demonstrating severe financial loss to the applicant or their employer, humanitarian reasons, compelling humanitarian reasons that necessitate urgent action, USCIS errors, cases where delays are due to errors by USCIS. National interest, situations benefiting U.S. national interests. Documentation for expedited requests. To support an expedited request, applicants should provide full name and contact information. Include the applicant's full name and contact details. A. Number. Provide the applicant alien registration number, A number. Receipt notices. Include copies of receipt notices for the relevant applications. Supporting documents. Submit evidence supporting the expedited request, such as letters from employers, medical documents, and proof of financial loss. Working with congressional representatives. Involving a congressional representative can increase the chances of an expedited request being approved. Representatives can submit inquiries on behalf of constituents, emphasizing the urgency and providing additional support. Practical tips for managing EAD delay. Stay informed. Regularly check the USCIS website and other reliable sources for updates on EAD processing times and policy changes. Staying informed allows applicants to take timely action when necessary. Consult with immigration attorney. Seeking advice from experienced immigration attorneys can provide valuable insights and strategies tailored to individual circumstances. Attorneys can guide applicants through complex procedures and represent them in legal actions if needed. Explore financial strategies. Applicants facing delays may need to explore alternative financial strategies to mitigate the impact. Options include temporary employment, seeking temporary or part-time employment that does not require an EAD. Savings and investments, utilizing savings or investments to cover expenses during the delay period. Support networks, relying on family and community support to manage financial challenges. USCIS's recent changes to EAD policies represent significant steps towards improving the processing and accessibility of work authorization for immigrants in the United States. While these changes address some of the long-standing issues, challenges remain, particularly in the face of persistent delays and administrative backlogs. For individuals affected by these delays, understanding the available options, whether through expedited requests, legal actions, or alternative financial strategies, is crucial. By staying informed, seeking professional advice, and leveraging available resources, immigrants can better navigate. That is all for today in this video. What are your thoughts on this? Please let us know in the comments section below. Thanks for watching the entire video. Hopefully, the information is useful to you. See you later in the next video. Till then, take care.
Hello everyone, welcome back to our channel US Immigration News. We hope you're doing great. Well, in today's video we'll be talking about updated USCIS rules for work authorization, automatic EAD, and mandamus litigation speed up. In recent weeks, the United States Citizenship and Immigration Services (USCIS) has implemented significant changes to its Employment Authorization Document (EAD), policies to streamline processes, reduce backlogs, and support immigration workers. Key changes include decoupling EAD from other immigrant benefits, automatic EAD extensions for additional categories, and exempting certain visa holders from needing an EAD. One major change is the prioritization of EAD applications, which are now processed separately from Advance Parole (AP) applications. This aims to reduce backlogs and expedite EAD issuance. Additionally, certain visa holders like H-4 dependent visa spouses now receive automatic EAD extensions if they file a renewal application before their current EAD expires and hold an unexpired I-94. This helps prevent employment disruptions and financial instability for families relying on dual incomes. Furthermore, USCIS updated its guidance for E and L visa non-immigrant spouses, allowing them to use their I-94 form as a proof of employment authorization, eliminating the need for separate EAD. This change simplifies the process and reduces the administrative burden on both applicants and USCIS. For H-4 visa holders, the automatic extension of EADs is crucial, allowing them to continue working while their renewal applications are processed. E and L visa holder spouses also benefit from the new policy, enabling them to start or continue employment without delay. USCIS also announced a policy update from U visa petitioners, granting employment authorization and deferred action to those with pending bona fide petitions. Current EAD processing times vary, with I-485 EAD processing take 2 to 6 months and H-4 spouses EAD processing ranging from 4 to 8 months. Delays are caused by factors such as office closures during COVID-19 pandemic, biometric appointment delays, and resource constraints. Mandamus litigation is an option for those facing unreasonable delays involving filing a lawsuit to compel USCIS to take action. Expedited requests supported by documentation and potentially involving congressional representatives are another strategy to address delays. USCIS recent changes aim to improve EAD processing and accessibility. However, challenges remain due to persistent delays and administrative backlogs. Understanding available options, seeking professional advice, and leveraging resources are crucial for affected individuals.